This is the In Focus podcast from The Hindu.
Hello and welcome to another episode of the Hindu's In Focus podcast. I'm Zubaida Hamid, your host for today. Exploitative work conditions faced by Indians in the Middle East is not new, but the recent reports emerging from Saudi Arabia's ambitious $500 billion Neom project are shocking. A recent documentary alleges that 21,000 foreign workers have died and 1 lakh have gone missing since 2017 while working on projects that are part of the country's Vision 2030 initiative. Earlier this week, Nadhmi al-Nasr, the longtime chief executive of the Neom project, departed, and while there was no reason given, reports indicate that Mr. al-Nasr had earned a chilling reputation managing workers of the project. But despite sometimes horrific work conditions, multiple deaths, and the continuing use of the kafala system, around 9 million Indians continue to compete for jobs in the 6 Gulf Cooperation Council countries of Bahrain, Kuwait, Oman, Qatar, Saudi Arabia, and the UAE. India has one of the highest remittances from its citizens working abroad in the world, with the figure estimated at $100 billion as of 2022. And yet, policies and laws to protect migrant workers are scarce. So why do young Indians continue to go abroad for semi-skilled or unskilled work? Are these last resort options, or are they still seen as lucrative employment offers? Why do there continue to remain minimal protection for those who go to these countries? Has the pattern of migration from India changed? And does the Indian Immigration Act need an overhaul? We delve into these questions and more with Saurabh Bhattacharjee, Associate Professor of the National Law School in Bengaluru and Co-Director of the Centre for Labour Studies. Good evening, Professor Saurabh, and welcome to the Hindus in Focus podcast.
Good evening, Zubaida. Thank you for having me here. It's a pleasure to be on this podcast.
Professor, let's start with a little bit of background. Around 9 million Indian workers compete for jobs in the 6 GCC countries of Bahrain, Kuwait, Oman, Qatar, Saudi Arabia, and the UAE. Why are these numbers so high from India?
So there are several factors that may explain the overwhelming dominance of Indian labor force in Gulf countries. And there are push factors, including pervasive unemployment in India, despite fairly significant economic growth that we have had post-liberalization. It has been a jobless growth, as several economists have documented. And even where there have been growth in employment, it has been lopsided, with large pockets of the country not benefiting significantly from economic liberalization and the limited job creation that has happened. And as a result, we have not been able to absorb the huge number of unskilled, semi-skilled workers in our country. And they have found Gulf countries as a more suitable option for looking at livelihood avenues. And on the other hand, when we look at the pull factors, the post-oil boom development that Gulf countries have seen saw a massive development, an increase in supply and migration of Indian labor, and not just Indian, other South Asian labor to various Gulf countries. There's also documented literature showing that post the Iraq war, where Saudi Arabia disallowed workers from certain countries which were not part of the Allied campaign, so to speak, also led to further increase in Indian workers. And at the other end of the spectrum, there's also been a shortage of highly skilled professionals and workers in some of the Gulf countries as they expanded post early 1970s. And that void had also been filled up by Indian professionals and other South Asian professionals. But despite having such high skilled professionals being employed in Gulf countries, when we look at the numbers, it's pretty evident that a substantially large majority of workers in these Gulf countries are semi-skilled, unskilled, manual labor, carrying out work that does not perhaps meet the definitions of fair and decent work, by most globally acceptable standards.
Thanks, Professor. Let's go into this a little bit more. Getting into the specifics of the Neom project that has made headlines recently, it has already attracted criticisms for its harsh working conditions, something you just mentioned now, and for the behavior of its top management when it comes to how they regard their workers. Would you say that this is a common scenario for Indians working in these countries? And if so, does this mean that these jobs are the last resort for our workers, or do they, in the sense that there is no other choice, or are they seen as lucrative options?
I think it's a bit of a both. On one hand, it does appear from the reports that have been published around the Neom project that poses certain peculiar challenges, if not in kind, certainly in the scale. The very scale of the project itself has meant that abuse seems to be far more endemic in it. But at the same time, we must understand that there have been complaints about conditions of labor, especially migrant labor, in several Gulf countries, and not just the Neom project and not just Saudi Arabia. And we are in 2024 November right now, but when we look back, there was considerable attention that conditions of labor in Qatar had attracted in the run up to the Football World Cup. And with Saudi Arabia's bid for the Football World Cup, there is renewed attention given to labor conditions in Saudi Arabia. But with respect to absence of dignified conditions at work for several of our workers, it's been a concern that has repeatedly come up, particularly centered around the kafala system that has been followed in numerous of the Gulf countries. And despite some liberalization and reforms that have taken place, it does appear, based on the complaints that human rights watchdogs have and labor organizations have documented, that those reforms and their adequacy requires significant improvement in the days to come if we need to ensure decent work and fair working conditions for all the migrant workers. And as far as the question on whether this is a last resort or these are seen as lucrative options, again, perhaps one would say that there is a bit of both. For many unskilled workers, the wages, despite being low and despite the serious complaints about wage theft, it still is seen as more attractive than the sort of wages and remuneration that workers receive for similar work in Indian conditions. So it's certainly seen as a lucrative opportunity. But for many others, it may also be based on their channels of social network and connection, that those may be one of the few meaningful options that may remain. So I would say again that it's a bit of both for workers who do migrate to Gulf countries, including Saudi Arabia.
Let's talk about the laws a little. India gets a lot of remittances from its citizens working abroad, perhaps more than any other country. The figure was pegged at about $111 billion in 2022. What is India's position with regard to our workers abroad? Are there any protections for them? What is the legislation surrounding this?
The economic remittance may perhaps explain why the Indian state has been hesitant and in trying to seek protection for migrant workers in various Gulf countries, because they would not want to lose out on that remittance that plays a vital role in our domestic economy, and some states much more than others. But in terms of legal framework, India has had a long history of regulation of migrant workers who go for unskilled or semi skilled work. If you look historically speaking, there was considerable churn within the Indian national movement against migration of indentured labor. And you've had major figures in the national movement call for regulation, and you had Indian Immigration Act of 1883 that had been passed for the first time, which followed certain subsequent Immigration Act as well, primarily targeted at protecting workers from being subjected to migration under the indentured labor system. But having said that, the more modern avatar remains the the Immigration Act of 1983, which provides for certain regulatory requirements. On one hand, it makes a distinction between people who require a immigration clearance and those who do not. And we have a two-track system of issue of passports, and people who don't have minimum academic qualifications and don't meet certain other requirements do receive what is called as a ECR passport that requires immigration clearance before moving out of India. And the bureaucratic imagination was that the Indian state, before authorizing any form of immigration clearance, would exercise certain checks on the conditions of work that these migrant workers would be subjected to. And even now, we have processes through which foreign employers and contracting agencies are required to submit documentations detailing the working conditions, detailing the living conditions. And based on that, immigration clearance is supposed to be provided. And it's necessary that recruiting agents register with this officer called as the Protector General of Immigrants. But the question mark remains on how robust this framework is. First of all, how strong our bureaucratic framework under this Protector General of Immigrants is a question that requires some degree of attention. But secondly, the political will that Indian government has towards protecting migrant worker perhaps also requires further scrutiny. And thirdly, I would emphasize on the fact that the Immigration Act of 1983 was built around the realities of migration of prevalent in 1970s and early 1980s. And now when we are in 2024, where some of the patterns of migration has changed, and when we talk of unskilled labor and people who are most vulnerable, this dichotomy that they're drawn between people who do not have matriculation certificates and those who have completed class 10 certificate, that's not relevant at all. In fact, you'd have people who would have basic high school level qualification, very often college degree as well, but similarly vulnerable when we look at the conditions of work that they are subjected to, when we look at the forms of recruiting which border on trafficking that they are subjected to, then we need to have a very close relook at the Immigration Act 1983 and its fundamental pillar of this dichotomy based on educational qualification. And that's why bills were proposed, and yet they have not really found adequate support within the government. And we require broader consensus within the political class and the policymakers towards an overhaul of the existing Indian Immigration Act. I must also say, in terms of legal framework, that apart from the Immigration Clearance Act or the Immigration Act and the Immigration Clearance Framework that we have, India has also signed a whole range of memorandum of understanding with several Gulf countries. The Ministry of External Affairs has also said that India has signed certain agreements on labor cooperation and with major destination countries. In fact, that was a parliamentary statement that the Minister of State in the Ministry of Parliamentary or External Affairs, had submitted before the Parliament. But again, there's very little documentation on the adequacy of the measures that have been taken so far.
Would you say that the exploitation starts from here? You talked a little bit about the recruiting systems, the system of agents and workers having to first pay in order to be able to get a job abroad. Would you say that it starts from here and then the exploitation continues in these Gulf countries?
Oh, yes, indeed. And I would say that there is a continuum, that we should not completely divorce the question of protection or the absence of protection for domestic migrant workers and migrant workers who are recruited through various agents for Gulf countries as well. We are seeing these practices very pervasive, where you have, through several contractors and subcontractors, people hired, often with very little information, often based on systematic misinformation shared with the workers, where they have a limited option of backing out because their passport, or in the Indian context, within domestic migrants, you may have their ration cards and other identity documents being taken away, and wages not being paid in time. It's only at the end of the overall tenure that wages are paid. These are practices that have become deeply pervasive in the way in which contract labor is hired. Migrant workers are hired through contractors and subcontractors, and we are seeing that play out even with migrant workers hired for Gulf countries. But the vulnerability for such migrant workers become even more acute when we are talking of transnational migration, where the option of leaving their work and returning back to their home is almost non existent. And in such cases, these practices of recruitment border on trafficking, border on forced labor. And that's why I would say that the problem indeed is a one that starts with the recruiting at home itself.
You talked a little bit about the MOUs that the Indian government has signed with certain countries abroad. Are there is the Indian embassy empowered in these countries to be able to help our citizens? How does it work once you're over there?
It's a slightly tricky question because, on one hand, MOUs and agreements that have been signed commit India and the various destination countries in the Gulf to cooperate and help in addressing labor complaints, help in rescuing labor wherever complaints of violation are brought forth. And to that extent, there is a channel of communication and diplomatic engagement that these MOUs and employment and cooperation agreements have opened up. But at the same time, our embassies and diplomatic staff have a limited powers to act independently in any way. So therefore, while they have an obligation towards our citizens, and they need to ensure that sufficient measures are put in place, both for information sharing as well as avenues of redressal, but at the same time, they will be dependent on the host countries for any meaningful action in response to the complaints. And as we are seeing, despite some of the reforms that countries like Qatar or Saudi Arabia have put in place, even now the kafala system and the system of engagement remains fundamentally exploitative. And the ability and willingness of the host countries also is suspect. There, while there are some improvement, the lack of political will is not something that's unique to India itself. It's clear that even the host countries have not been sufficiently responsive beyond some cosmetic measures.
So, despite all of these MOUs, the kafala system, which in its nature in itself is exploitative, remains unchanged, correct?
Some claims have been made that they have been stopped altogether and they have been reformed. But when you look at documentation that exists, it appears that its core has not changed at all. While there have been some changes on the margins, but the basic norms where employer exercise enormous control over the exit of workers, over the system of payment of wages, the limited access to redress for workers, those haven't really changed in a fundamental manner.
Let's go back to a little bit about what you were talking about earlier, Professor. You said that one of the problems with the Immigration Act was that it does not reflect the patterns of migration that exist now. Talk to us a little bit about that. How has this changed within India? Are the same states that used to still continuing to send workers abroad, or has this completely changed?
The number of states who are sending workers has certainly expanded. If the traditional perception was that it's the some of the states like Kerala and other western coast states have been sending most of the workers to the Gulf, there are literature that shows that that's not anymore the case. In fact, some of the hinterland states like Uttar Pradesh, Bihar, Punjab has been sending a significant chunk of migrant workers to Gulf countries as well. There's also been a change in terms of types of workers who are going in. It's not just the construction workers and those associated with other forms of ancillary work who are going in. We have a vast pool of domestic workers who have now going to Gulf. You have other little more semi-skilled workers who have been going into Gulf countries. So in that, both in terms of types of workers who have gone and who are going in the recent years, and the states which are sending, there is certainly a greater expansion that has taken place. But having said that, it would still be correct to say that Kerala still remains one of the most dominant source of labor to the Gulf countries. And even in terms of political support at the state level, I think that's a state which has shown incipient signs of changes taking place, at least in terms of policies, unlike many other states which have been relatively less invested in extending policy protection for migrant workers going into Gulf countries.
Let's delve into the Kerala scenario in a bit. If you could just tell me a little bit about, you said even the nature, the kind of the sort of kind of jobs that they go for has changed. Would you say that the number of skilled jobs has increased, or has that remained stagnant and it's still semi-skilled and unskilled jobs that form the substantial chunk of work that is abroad?
Overall, I think it would still be a situation where semi-skilled and unskilled workers remain the most dominant form of workers mm, who are going to Gulf countries even now. But yes, the number of skilled workers have gone up. Even within the semi-skilled workers, the type of work for which we are seeing workers leave for Gulf, we are seeing slight change. So, in that sense, even if the overwhelming majority of workers still remains unskilled and semi-skilled, perhaps we are seeing a change within the sort of semi-skilled work that workers are going for in the Gulf countries, and not just the traditional forms of manual labor for which workers have gone.
You said earlier that many of the Gulf countries simply weren't invested enough, did not have enough political will to perhaps bring about better working conditions over there. How about domestically? We talked a little bit about Kerala, and it has a long history of migration, as we know. They have put in a few policies like accident insurance, life insurance, some form of medical assistance, even policies to reintegrate workers who come back from abroad into the domestic economy. Do other states have such policies? Is this a real need that is being felt in other states?
Conversations have begun in some states, but I'm not so certain that we have concrete measures that have been put in place in the same way in which Kerala has done. And despite quite a bit of mm, campaigning from labor organizations, what we have indeed seen is the challenge that many states don't want to mm, lose out on the remittances that workers send back. There's also a lack of political constituency which speaks for migrant labor residing and working in various Gulf countries, unlike with IT professionals or educational migrants, the students who have gone to various countries. Most of the migrant workers do not have the same kind of political capital that we have seen with certain other categories of migrants. And that may also explain why we have had very limited traction for claims of protection for migrant workers in states other than Kerala. There's been some attempts done, especially with respect to North Indian state like Punjab or even in West Bengal. We've had some minimal conversation, but I'm not so sure to what extent we can say that there are concrete policy measures that have been instituted which allows for meaningful redress for workers.
Last couple of questions, Professor. One is that what would you say is the need of the hour in terms of legislative change? Does it have to start, as you pointed out, domestically from the recruiting system itself? And what can states and the center do in terms of protections? We know that welfare boards don't really amount to much. The welfare board for construction workers has shown us that. What would be the concrete legislative protective measures that could be put in place domestically?
There are two, three different strands of action that can be pursued. One, of course, is the Immigration Act framework that requires an overhaul, and registration and monitoring of recruiting agencies. The system of clearance requires strengthening. But additionally, in terms of legal avenues that are existing within labor laws, one that I see having certain potential is to strengthen the liability within existing labor statutes for contractors and recruiting agencies. Some of our labor statutes have some minimal scope for extraterritorial application. To give you an example, we have a legislation called the Employees Compensation Act, which entitles workers to receive compensation for accident injury from the employer. And where it's an employee hired through a contractor, the principal employer is also liable to pay compensation for injuries that result in disablement or that results in death of a worker. And that has a scope for extraterritorial application. And I certainly believe that the legislature needs to think more seriously about holding recruiting agencies and other contractors and subcontractors liable, even for accidents that may take place outside the country. We have had insurance model that has been proposed and introduced in some of the states. But I do believe that if Employees Compensation Act was based around the idea of employers' liability, then that's something that must be extended with respect to migrant workers who suffer workplace injuries outside. Similarly, when we talk of unionization, there is no specific explicit territorial limit with respect to collective bargaining and trade unions. And while it may have a limited impact for host countries, because unions that are registered in India may not really be able to do much directly in the host countries, but certainly we must allow for registration of workers in the Indian jurisdiction itself, so that they can collectively bargain and put certain pressure on the governments, whether the central government or state government, towards appropriate policy measures that could be introduced. Similarly, when we talk of social security measures, while you did say that welfare boards do not work and have not worked very well in most instances, but the fact remains that there are other social security schemes. And when we look at things like employee state insurance, when we look at provisions like employees provident fund, some of those have worked relatively better. And we must seriously explore ways in which, if not the host country employer on whom Indian state may not have any direct jurisdiction, at least the contractors and other agents and subagents must be held liable as a proxy for the main employer, and contributions to employees' social insurance schemes, the employees' provident fund schemes must be introduced. Perhaps we cannot replicate the same mechanisms that we have for our domestic workers, but there are ways in which at least some protection can be extended. And when you look at the Social Security Code, for all the criticism it has received, it does allow for expansion of both employee state insurance as well as employees provident fund to new categories of workers. And I do believe that there is an avenue that can be utilized by the state for extending some of these protection to migrant workers as well. The other avenue, which I think is not so much our domestic labor laws, but Indian state needs to seriously think about investing in strengthening labor protection at the international level. Just to give you an example, we in India, we have not ratified the Migrant Workers Convention, the International Convention on the Protection of Rights of All Migrant Workers. And while it may not have an immediate impact, given that most of the Gulf countries have not ratified that either, but nonetheless, to strengthen the diplomatic engagement with these countries, also join the international community in the limited campaigns that are taking place in and within various human rights forum for protection of labor rights in various Gulf countries. I think India needs to look at that and participate in them in a much more wholehearted manner than they have done. The difficulty is, of course, there is a risk that we will lose out on remittances. Difficulty also is that we will not want to, in any manner, endanger diplomatic relations, not just for economic remittances, but several other strategic benefits that India may draw from closer cooperation with Gulf countries. So, those headwinds we'll have to negotiate. But I think certainly both at the domestic level as well as the international human rights law, Indian state needs to look at specific interventions that can expand the protection or space for protection for the migrant workers.
Have other countries who send their workers abroad managed to do this to some extent?
If you look at the South Asian countries, certainly not. And I think the same impulses that have led Indian government to be somewhat tentative in speaking up for our workers with various Gulf countries also applies with equal and perhaps larger degree to other South Asian countries as well. But when you look at whether it's the Neom project or the Football World Cup or future bids for the FIFA World Cup, all of these are opportunities where greater degree of international scrutiny is being placed on labor practices in Saudi Arabia and other Gulf countries. And I think Indian state needs to use this in a, of course, in a way that does not harm our relations and does not end any prospect for long-term cooperation on labor protection. So it has to be incremental, but nonetheless, these are opportunities that will have to be used by Indian government. And if India cannot, if we claim to be one of the uh, larger and faster growing economies in the world, if we claim that we are acquiring greater national power and diplomatic resonance, we must certainly utilize these opportunities. And we owe it to our workers to ensure that basic minimum protection and standards of labor are there for our workers wherever they work.
Last question, Professor. We were talking about salatiums or amounts that could be paid in cases of death or disability from the employer's side. Um, we know that the Pravasi Bharati Bima Yojana, which provides a death and disability cover of 10 lakhs to Indian migrant workers in case of work-related disability or death, exists. But from media reports, this scheme is not put to much use primarily because most of the deaths are certified as not being due to work related injuries or not being because it was inside a working space. Is that something that needs an area that needs to be looked into further? Because if they're going to be if these deaths are going to be certified as not having had happened due to working conditions, then obviously the families of these people are not eligible for that compensation.
Indeed. And I think you have hit at one of the weaknesses of the existing insurance protection that has been put in place. I'll have two responses. One, that first of all, while the scheme draws back on the Immigration Act, it's still a scheme that does not have a statutory entitlement of the sort that Employees Compensation Act or the Employees State Insurance Act provides for. So ideally, there must be a statutory entitlement, and which is not dependent on executive discretion, which any governmental scheme bereft of statutory entitlement is. Secondly, with respect to certification, it's indeed a challenge, especially when we have limited bureaucratic and diplomatic capacity to monitor and verify such claims in various destination countries. But in some of our laws, and I go back to the example of Employees Compensation Act, there are several presumptions that have been created, whether it's in the Employees Compensation Act or in Employee State Insurance Act. For some of the accidents, we presume them to be accident in the course of employment and arising out of employment subject to certain condition. And I don't see any reason why similar presumptions cannot be explored, albeit subject to certain qualifications, so that mm, it does not lead to abuse of mm, such a provision. But at the same time, there are options where some of the hurdles of obtaining certification can be circumvented by creating legal presumptions where if a worker has worked for certain duration and thereafter suffers an accident in the workplace, then it shall be presumed to be an accident in the course of employment and arising out of employment. There are also presumptions that the law provides for certain occupational diseases, mm, mm, and injuries where the accident may not have happened exactly at the time of the work. And I think we need to look at similar presumptions through a statute for migrant workers as well. And the insurance scheme that has been put in place does provide for a substantial amount, and 10 lakh is not an amount that can be scoffed at. But nonetheless, because it lacks a bureaucratic statutory framework, because it lacks some of these provisions through which difficulties in proving a nexus between employment and injury has been bypassed in other legislations. It has not been meaningfully utilized by workers until now. The limited anecdotal reports and media reports indicate that there's not been a serious utilization of this provision at all. And that's where I think a statute which provides for guaranteed protection, and also not just dependent on government providing a payment, but holding the contractors and other subagents and subcontractors liable, also becomes an important way of ensuring accountability. So I think these would be some of my responses to the specific problem you highlighted.
Thank you so much, Professor.
Thank you so much for having me here.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.